5 seconds. Since appropriate steps have been taken by the government of Haryana in this matter and the required action has also been taken against the officers found guilty or dereliction of their duties. In view of these facts, it is not necessary to pursue this matter any further, keeping in view the attitude of the government of Haryana to take necessary action itself. This special leave petition is disposed of accordingly. The High Court of Punjab and Haryana allowed the CWP number 6675 of 1996 void its order dated 8/12/1997 and set aside the order of dismissal passed against the applicant. Against the aforesaid order of the High Court, the State of Haryana filed letters patent appeal before the Division Bench of the High Court. The Division Bench did not grant any stay of the order dated 8/12/1997. The applicant filed contempt petition as the respondents did not comply with the order dated 8/12/1997 passed by the High Court of Punjab and Haryana in CWP number 6675 of 1996. Thereafter, in compliance of the aforesaid order, the applicant was taken back in the services on 10/11/1998. The Division Bench of the High Court allowed the latter's patent appeal and set aside the order dated 8/12/1997 and remanded the matter to the learned single judge for deciding the writ petition afresh. On 15/1/1997, the applicant was again dismissed from the service. It appears that Inspector Rampal had filed writ petition bearing number 6675 of 1996 seeking reinstatement. That writ petition was pending in January and December 2000 when orders of reinstatement were passed. Thus, orders of reinstatement has been passed even though the matter was sub judice before the Punjab and Haryana High Court. The writ petition was pending even when this court dealt with the CRL MP. It was not pointed out to this court that a writ petition was pending before the Punjab and Haryana High Court. Had it been pointed out, this court could have directed that orders of this court be brought to the notice of Punjab and Haryana High Court. Writ petition number 6675 of 1996 reached for hearing before the Punjab and Haryana High Court on 9 December 2002. The Punjab and Haryana High Court, by order of the same date, has quashed the orders dated 29 March 1996 and 27 April 1996. Reading of the order dated 9 December 2002 makes it clear that the only reason why the termination of the service had been requested is because an impression was given to the Punjab and Haryana High Court that the dismissal and reversion orders were only passed because of the conviction of the officer and that After acquittal, there is no ground on which termination after revision could be sustained. A reading of the order dated 9 December 2002 shows that Punjab and Haryana High Court was not informed that an inquiry committee had found the officers guilty of dereliction of duty. The Punjab and Haryana High Court was not informed that a statement had been made before this court on 16 August 1996 and termination had taken place pursuant to the assurance given to this court. Also, the subsequent order dated 14th February 2001 has obviously not been brought to the notice of the Punjab and Haryana High Court. It appears to us that the government is colluding with the officer in trying to somehow or the other get him reinstated. In our view, this is playing with the courts. This cannot be permitted. We do not grant permission to reinstate Inspector Rampal. This order be brought to the notice of Punjab and Haryana High Court by the State of Haryana and by our registry. He further submitted that the effect of the judgment and order dated 9/12/2002 passed by the High Court of Punjab and Haryana was reinstatement of the applicant with all consequential benefit. However, in view of the order dated 14/2/2001 passed by this court, the said order could not have been implemented by the respondent. Is that Government of Haryana, without seeking leave of this court, as the order dated 9/12/2002 had been passed by the High Court of Punjab and Haryana upon being misled by the applicant and Government of Haryana. Respondent number 1. The question of implementing the same did not arise and was rightly rejected by this court in its order dated 3/11/2003.